Welcome everybody to our tonight's program, Meet the Mental Health Professionals Night. Before we begin, we have a couple of housekeeping announcements, as always. You will receive your MCLE certificate shortly after the program.
I'll do this so I can see.
Take a moment to complete the survey that is included with your certificate. Moving on to our sponsors. The Family Law section is sponsored by White Zuckerman, Warsofsky, Luna, Hunt, LLP, and Our Family Wizard. For White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practices services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Deborah?
This program is also brought to you by Our Family Wizard. Our Family Wizard is a secure co-parenting platform that supports divorced and separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in and exchanges, send messages, and more, all while thoroughly documenting their activity. We also want to make you aware that we have a few very exciting programs coming up. On May 4th, we have Direct Examination featuring Dan Jaffe. I understand it's experiences and stories that you just won't want to miss. Later that evening, we invite you to join us for our Meet the Judges night. Definitely going to be an amazing day on May 4th. And then join us later in the month for May 26th, when we have the quarterly installment of What's New in Department 2, where our very own Judge Pellman gives us everything we need to know about what's going on behind the scenes at the courthouse. With having said all of that, and with our thanks to Deborah Frank, Ellen Stein, I turn it over to you, Ellen.
It's my pleasure to welcome you to the third annual Meet the Mental Health Professionals Night. We appreciate your attendance and participation. My co-chairs, Deborah Frank, Joe Langlois, and I want to thank the Beverly Hills Bar Association for giving this program a home, and the California chapter of the Association of Family and Conciliation Courts for its co-sponsorship. Special thanks go out to Genna, Kathleen, and Jose at the Beverly Hills Bar for their assistance in bringing this program to fruition. Thanks are also due to Jenna Kang and Kendra Thomas, co-chairs of the Executive Committee of the Family Law section of the Beverly Hills Bar, for their support of the program. Our speakers, Susan Thrall of Family Court Services, Judge Harvey Silberman, Dr. Gitu Bhatia, and attorney Jeffery Jacobson, all gave generously of their time and expertise in preparing for this program. We're grateful for their participation and for their willingness to share a part of their evening with us. Let me direct you to the written materials for their bios so we have more time to spend hearing from them. We have a full program tonight. Susan Thrall will begin the program with an update of services provided by Family Court Services. Our panel discussion will follow. One of my co-chairs will review questions submitted by the audience, and you can do that through the chat function. And we may have some time to have a few of those answered by the panel. After the panel, our mental health professionals will each have a few minutes to introduce themselves. We have a lot of folks to meet, so we ask that you keep your remarks brief. At the end of the formal program, all attendees will have the option of being randomly assigned to 2 10-minute breakout groups. With that said, let's get started. Susan Thrall, will you tell us about what's going on at Family Court Services?
Of course. Thank you. Thank you very much for inviting me to provide an update on Family Court Services. This evening, I'm going to provide a brief discussion of our services we currently have available at the court, which includes both online and in-person services. As you all know, at the time that a case is filed with the court, parents receive an order to participate in mediation. This order informs parents of several things, including the option to settle their child custody issues through the court's Family Law Online Dispute Resolution Program. The online program enables parents to reach a child custody agreement on their own. It is accessible on the court's website at no cost to parents. The petitioner begins the process, and the responding party reviews the proposed plan and then provides a response either by agreeing or offering an alternate plan. The parties are guided through a series of questions, which can then result in a proposed parenting plan. The agreement can include legal custody, a time-sharing schedule, how parents will exchange their children, holidays, vacations, and any other special provisions parents agree to. If both parents agree, the program will generate a parenting plan agreement, which parents can then file with the court. Also, if a full parenting plan agreement is reached, parents do not need to attend their scheduled family court services mediation appointment. The order to participate in mediation also advises the parties of the mandate to complete the Our Children First online orientation program. It is a 40-minute online video which describes not only the mediation process, but reviews the effects of separation and conflict on children. After completing the orientation, parents can print their certificate of completion and then file it with the court. The program is available in both English and Spanish. Please encourage your clients to complete this orientation prior to their mediation session. It really helps set the stage for negotiation and helps parents focus on their children. Finally, if parents do not reach an agreement through the online program, they must participate in a mediation session with a family court services specialist. We have offices throughout Los Angeles County. We offer confidential mediation sessions by WebEx, and we have returned to some limited same-day mediation sessions. Our family court services specialists are mental health professionals trained to perform both mediation and evaluation services and receive ongoing training as mandated by code. Please remind your clients to complete the mediation intake form that is available on the court website by going to Divisions, Family Law, and scrolling down and selecting Child Custody Mediation Appointment prior to their scheduled mediation date. When an agreement is reached in family court services, parents have up to 5 calendar days or the day prior to the hearing to review their agreement with their attorneys and have the option to cancel if they change their mind. If the court needs additional information from a mental health professional, the court can order family court services to conduct a child interview or a parenting plan assessment. Child interviews enable family court services specialists to provide information to the court from the child, but does not include any recommendations. We are currently conducting child interviews remotely. There is a fee of $424. We have 2 types of assessments: 1-day parenting plan assessment, which is suggested for cases involving 1 or 2 issues, and a 2-day parenting plan assessment, which is reserved for more complex cases with more than 2 significant issues. The fee for a 1-day is $975, and for a 2-day, it is $1,950. During the pandemic, we modified the format of the assessments and we conducted them over 3 days, but we have returned to the 1-day and 2-day format. However, interviews may still take place prior to the scheduled date by either video conference or telephone. Testimony for both child interviews and assessments are done remotely by video conference unless ordered by the court that we appear in person. If fees for the child interviews and parenting plan assessments are not paid timely, they will be canceled. Parenting plan assessments must be paid within 21 calendar days from the date ordered, and the fees for child interviews must be received no later than 7 calendar days from the date ordered or the date of the interview, whichever comes first. If canceled, the parties and attorneys must seek reinstatement directly from the court. We also conduct full child custody evaluations under Family Code Section 3118. There is a fee for full evaluations. The deposit is $1,200 and the remaining cost is calculated based on the time spent on the case. Many of you may remember that the court used to have an in-person high conflict program for parents called Parenting Without Conflict. The court's online version is called Between Two Parents. This program is available in English and Spanish. It is available to parents who are ordered by the court and there is no cost. It is a 6-session online program with videos and assignments to be completed over a 6-week period, but within 50 days of starting the program. The program is interactive and draws from our successful Parenting Without Conflict program. After completing Between Two Parents, parents can complete the certificate of completion and then file it with the court. Just for your information, there is no reference of the program on the court website. It is only available to parents through court order. When ordered, the court will provide the parents a brochure with the program information. We also have several brochures that your clients may find helpful and are available on the court website. We have a series of 7 brochures called Creating a Parenting Plan that outlines parenting plan ideas for various age groups. The brochures are available by going to self-help tab on the court website and then selecting child custody and visitation. Family Court Services also maintains several online directories. The Private Evaluator Directory, which many of you may be familiar with, includes professionals who have applied and indicate they have completed experience and training to conduct evaluations. The Private Counselor Directory includes mental health professionals who indicate that they provide counseling services for families experiencing conflict surrounding custody and visitation with their children. And we also have a parent education referral list for high conflict parents, which provides a list of mental health professionals and online programs who provide specialized parent education focused on reducing conflict. The application and requirements are available on the court's website. Finally, I encourage you to check the website frequently as it is updated with detailed information regarding all our services. And I also provided a brochure for the child interview, the 2 parenting plan assessments, as well as the mediation process, and should be available in your handouts.
Thank you. Before you go, could you give us some idea what the timing is on accessing a parenting plan assessment?
Great question. So much like other areas around the world, there has been a lot of a great impact. The pandemic has impacted people's views of work, and we've had a lot of people, although they were ready for retirement, deciding to leave during the pandemic. And so at the present time, we're doing a lot of hiring. There is a long wait time at this point of several months. It depends which district location we're referring to, so I can't really tell you what the wait time is for each area, but it is rather long because, again, we are trying to meet our mandate of conducting the mediation sessions.
Thank you, and we appreciate the challenges the court's been under. Thank you again for spending your time with us.
No problem. Thank you for inviting me.
Okay, we're going to jump right into our panel discussion now, and I'm going to start with you, Your Honor. You've been on the bench for 18 years and practiced family law prior to taking the bench. What changes have you observed in the parties and counsel who appear before you?
First of all, hello, everybody. It's nice to see you all. I know I can't really see you, but I can imagine. Hopefully, I'll be seeing you all soon in person. You know, when Ellen and Deborah asked me to join a panel dealing with the sort of mental health issues, I really jumped at the chance. It wasn't a matter of having to twist my arm to come talk about this. And in our first discussions with everybody on the panel, I said the most striking difference to me is when I started, as Ellen was so indiscreet to remind you all, 18 years ago, I would say that anecdotally, perhaps 25% of my case load had issues of clinical mental health. And I include, firstly, these are my custody cases I'm talking about. And I'm including issues of addiction and issues of children on the autism spectrum in that number. But I'd say there were about 25% of the cases. Now, 18 years later, I think I can conservatively say 50% of those cases include mental health issues, clinical mental health issues. I'm not talking about the fact that people don't get along and they fight with each other. I'm talking about real clinical mental health issues. When I say 50%, I think I'm being really conservative in that number. A larger number agree with that. And if you combine those sort of clinical mental health issues with a definite change in the environment, the general environment, when it comes to just civil behavior, it's a huge change in what's presented to us in the courtroom. You know, we appear to live in a society now where if you don't agree with somebody, you're their enemy. And it didn't used to be that way. It would just be people can reasonably disagree. But I don't know that that happens very much anymore. It seems to be you're instantly an enemy if you don't agree with me. And this does not only go for the litigants, but it bleeds over into the attorneys as well. In addition to the extensive clinical health issues and addiction and homelessness, I find we deal with an exorbitant amount of parental anxiety, perhaps even to a clinically disruptive level that we didn't see before. So that's very difficult. The pandemic, of course, has brought some advantages, but many, many disadvantages. The impact on children, I'll give you just an example. Last week, 5 court days, I had major cases where in 2 of the cases, I had teenage suicide issues. Whereas I'd say in the first 10 years of my being on the bench, maybe I had 5 or 6 in all those years. And now in a week, I would have 2. The impact on not only teenagers, but preteens and even younger children in difficult clinical mental health issues is profoundly different. And you add to that returning veterans with post-traumatic stress disorder, and all the other kinds of events that have gone on. And as we've seen a rise in this, we've seen a huge decline in the amount of resources, which is a real problem. So also, there's a lot of pressure not to miss some of these clinical issues that appear, because as we all know from recent events in Sacramento and things like that, the outcome can be horrific. In Sacramento, we had a seemingly safe visitation order where you had supervised visitation at a church by a church elder. And one of the parents came in and murdered the children and the church elder supervising. So to say things have changed would be an understatement. And I spend a lot of my day trying to figure out how and where to get mental health resources, which goes way beyond just who's insured or who's not insured. It often focuses on the fact that for many of the issues very specific to the way they play out in family court, we have a shortage of clinicians trained in those areas. And of course, cost is a difficult thing, especially living in a city like Los Angeles, where it's so expensive and where there's an epidemic of homelessness. So, Helen, a lot of things have changed since there, but it's, I think part of the problem really is that I don't know that we as a society has really come to terms with issues of mental health and the profundity of them. There's still so much stigma around the issues involving mental health that create further barriers to accessibility. And it's just real challenging, really challenging.
So how has this new environment changed how you see your role, if at all? Are you still going to be solving all of these problems in your courtroom for us?
Well, I don't know that I see my role as any different. And my role kind of changes from time to time. Sometimes I'm mediative, sometimes I'm the super parent. I have different roles there. And I don't know that those have changed that much over the years, but certainly I've learned to define success very differently. I think when I first took the bench, there was an attempt to really fix many of the problems that I saw. And I've slowly come to some awareness that there are a lot of situations that are beyond my ability to fix. And so I usually adjudge myself by determining whether or not what I've done has made life just a little bit better for a child. And if I can manage that, then that's a success.
And maybe that's a good reminder for all of us on this this Zoom this evening is to recognize the limits to what we can and can't do, and also recognize our successes when we have them. Thank you. Jeff, you litigated for many years before limiting your practice exclusively to mediation and collaborative cases. Are you observing the kinds of changes Judge Silberman described in your practice?
So the simple answer, Ellen, is yes. I'm not a mental health professional, but I certainly come across more cases where I hear about clinical mental health issues that Judge Silberman alluded to. I would just say, as far as trends that I'm seeing in mediation and collaborative, people are struggling. And I see escalated conflict. And while people might agree to consensual dispute resolution processes, it doesn't mean that the conflict isn't there. And it doesn't mean that, you know, some of the themes that we see in litigation don't exist even in these CDR cases. I see cases where there's depression, anxiety, but I think what I'm seeing most of these days are issues involving children, particularly adolescents who've struggled during the pandemic, who've had issues, and I'm seeing that a lot more than I ever have in my career. I'm also seeing the demographic of how parents deal with college-age children. This simple paradigm of, your high-achieving kid graduates from high school and goes off to college. Certainly with the pandemic and where we are now, I'm seeing a lot less of that. I see more college-age kids living with parents. Really leads to, from the parent standpoint, more uncertainty, more concern, and those issues are very present. So those are the things that I'm seeing. And while I'm not in a courtroom and I'm certainly not litigating these days, those themes still exist in my cases. And I would agree, as to seeing the same trends that Judge Silberman described.
And Gitu, I'm expecting that you're also seeing those things in your practice. Do you have anything to add to what Jeff and Judge Silberman have said? And you're muted.
Oh, sorry. So yeah, I'm observing some of the same things. And actually APA did a study on the level of stress in America since COVID happened and all of the, political changes and the racial unrest and so forth. And really what they're observing is validated by these studies, that the rates of anxiety, depression, the level of uncertainty that people are experiencing has gone up. There's more domestic violence. Child abuse during COVID times was sort of increasing, but not known to people because they weren't going to school and observing the bruises and so forth. So the level of mental anguish and disturbance and trauma certainly has increased in the last few years. And, social media was one of the things that was also contributing to the higher level of anxiety, depression among teens and suicidality that Judge Silberman talked about. So mental health needs and issues have definitely increased in the last few years. And unfortunately, the resources are limited and few often.
And Ellen, if I might jump in addition to the longstanding issues that Jeff, Gitu, and I have talked about, there are emerging issues that I certainly never thought I'd have to deal with. I mean, I'm dealing with issues of whether or not I should order puberty blockers for transgender children. And these new issues have come up again with limited, if any, resources or limited access to clinical data as to how to properly make these kinds of orders. So as I said, in addition to the issues that Gitu and Jeff and I have outlined, there are these emerging issues with no clear guidance that I've gotten as to how we get clinical assistance for these issues.
When we were planning this program, there was a consensus that there is a huge need and limited availability of mental health services to address this explosive increase in mental health problems. I'd like each of you, if you'd like, to talk about where that you see the most need, where mental health professionals might be, if they're looking to develop new areas where they might be training, and also particularly for folks of low and more moderate means, what services might be available to them. Do you want to start, Your Honor?
Sure. I mean, it's an easy question with no easy answer to it. I'm constantly in search of resources for people who appear in front of me. And it's not even just access due to financial ability to pay. Obviously, the bigger burden is borne by low-income people who have to go through the very limited number of public resources, which often come with long waiting lists and access to just trainees, that those services that will accept Medi-Cal. But in addition, even the middle class and upper class folk who can afford private services, to find services that are, and clinicians that are particularly trained and attuned to the very specialized issues that we see, is challenging. So often I see there's exhibited very negative and unproductive behavior by one parent to the other, and they'll go seek therapy, and they'll seek a very traditional model of supportive therapy, all right, which only ends up serving to validate the negative behavior we're trying to get them to address. And so I know I've taken to making specific orders when I order therapy that these are the issues the court sees and would like the therapist to address in a more confrontive behavioral modification manner rather than traditional supportive therapy. And it can be difficult to find clinicians who are trained and able to supply that. So on the less financially able end, we have a vacuum of services, and those provided mostly by trainees with long waiting lists. And for the people who can't afford or are privately insured, we often have trouble finding people trained in the very specific kinds of clinical mental health issues that we find in our kinds of cases.
Thank you. One of the results of the pandemic was that many people moved out of the jurisdiction, at least temporarily, and out of state. And like attorneys, mental health professionals are licensed state by state. Gitu, could you talk about the ability of a mental health professional licensed in California to work with folks out of state?
You're right that we are limited to California, and wherever we're licensed is where, but we also have the ethical responsibility of not abandoning our clients while you're, working with them. So I found that by calling our insurance company, you can find out your own insurance company, you can find out which states allow for you to work temporarily with a client who's possibly moving, or especially during COVID where they relocated for a temporary period of time for support from their extended families, that there's a certain number of sessions you can have during the year, almost like 20 sessions in one state that I applied for. And if you're in good standing in your own state, that is something is permissible for some of the states, not all. And APA has a list of telehealth corresponding, states that will allow that to happen. So that was a good thing during COVID that we got to overcome some of these barriers, at least for a period of time until they can find a local therapist, which makes sense because we're also not able to necessarily find emergency crisis kinds of services if they don't live in your own state or your own city. So that's something to be aware of.
Yeah, but
Right.
Unfortunately, this is a barrier to some of the kinds of therapy we order. To find somebody to do, for example, co-parenting counseling when one parent has moved out of state, which we see frequently now, is very, very difficult to find anybody if we can find anybody. So I often now have complete barriers to mental health intervention on a co-parenting level when one parent or the other has moved out of state. It's a real problem.
Jeff, are you finding that with the abundance of work available for mental health professionals that you're having difficulty finding mental health professionals to do certain of the kinds of services that are helpful to us in family law?
So I'm definitely seeing that there's way more demand than supply of really skilled practitioners who specialize in co-parenting issues and the things that we deal with every day in family law. Those mental health professionals are very, very busy. It's not uncommon when I'm, trying to make a referral for somebody, for a mental health professional to be involved in a matter, for the question to be, hey, is this going to be messy? Is this going to be a lot of work? Look, everything I do is covered by mediation confidentiality, right? I thought about making a t-shirt that says the following correspondence has been prepared for use in mediation only. right? That's my world. It's the world of confidentiality. And the same thing goes for mental health professionals who are involved in my cases. But even so, I still get that question, is this going to be a difficult case? Because the feedback I'm getting from mental health professionals is there's just way too much work and not enough time, and I find them being more and more selective. So I'm thinking of it from my lens of consensual dispute resolution and everything being covered by the umbrella of confidentiality. So, the feedback I've gotten from other mental health professionals is they're not going to be touching any case where there's any possibility of them being subpoenaed or speaking with a custody evaluator or otherwise getting sucked into the vortex of litigation, right? You go back to some of the things that Judge Silberman was talking about in terms of lower income families. It's a real problem, and finding trained people, in my cases where generally people have money is challenging enough, let alone people who don't have money. And again, I'm finding a challenge with mental health professionals being able to take on my kind of cases, let alone, cases that could potentially go to litigation. I just kind of see a trend where many mental health professionals simply will not touch those anymore. And I'm not sure who's going to service those families.
And Ellen, as difficult as it is, as Jeff was saying, to find therapeutic providers, clinicians, to find MDs who have any specialty in psychiatric care is even more difficult. To find a good psychiatrist who has had any training in the kind of mental health issues that we deal with regularly in our courtroom is very rare, very rare. We have, as far as I know, a handful at best. And with the issues becoming more complex, with the rise in PTSD and schizophrenia and the other really profound mental health issues that we see, the lack of proper MD training in any of these areas is really an invitation for trouble.
I would agree that the key word from both what Jeff and Judge Silberman said, that there aren't enough people trained in working with families going through divorce and separation. And that's something that we can all agree on, that there is limitation there. But in terms of mainstream problems, I think one of the things that the pandemic has allowed us to see, there's a lot of online programs that platforms that people can get services more readily, more in a timely fashion, and at a cheaper cost. So there, that's something for all of us to consider as well, for therapy for children or for individuals who are just coping with divorce and overwhelmed or traumatized by many aspects of life besides going through divorce and separation. So, and also one of the resources we think we should consider are the schools of psychology, professional psychology in the area all have community clinics, and they're, students, but they're supervised. And so that's an option. And community clinics like D.D. Hirsch and other agencies can be tapped into, although I think the people on this Zoom today could serve as mentors and help direct mentees towards learning more about working with divorcing families and all of that. So I think and AFCC is a great resource for that as well. We seriously need better training in this area. As mental health professionals, we get trained in working with addictions, we get human sexuality and courses that are required that affect everybody, but divorce affects a huge percentage of the population. And that's not always taught or required at all in many of the professional schools. So that's something we can all kind of work towards changing.
Thank you. And we'd like to solicit from audience members, if you have thoughts, mental health professionals, what would encourage you and your colleagues to do more of this work? Or attorneys, how you get mental health professionals to work with you and your clients. You might want to share those via chat.
Yeah, I think just to add that reassuring therapists that confidentiality is primary, as Jeff was talking about, and reminding them that not everybody gets called out by the board of psychology, or that they're going to have to deal with the board issues. That I think would help people move towards working with this population.
Great. Thank you. Now, let's start even before a case is filed. Sometimes we have potential clients come to us who really aren't sure whether or not they want to go ahead with a divorce or work on their marriage. And I think most of us are familiar with individual counseling and couples counseling. Could you just explain briefly what discernment counseling is?
So discernment counseling is something that was named and coined by Bill Doherty in Minneapolis, I think. And it's a very focused kind of therapy that it takes from 1 to 5 sessions in helping people decide whether they want to go through divorce or possibly go through counseling and try it for 6 months before filing for a divorce, or then definitely deciding to go through a divorce. So the often it's people with a mixed agenda. So a couple with one person leaning out and one person wanting to stay in. That discernment therapy is suggested or an option, so that it's not long-term therapy, it's not couples therapy. It's really to decide where they stand and whether they're ready to divorce.
Thank you. Jeff, would you discuss circumstances, and we all see them, where a client's mental health might interfere from the get-go with their ability to participate in the proceedings or in case resolution? And how do you raise that issue with the client, if at all? And what mental health services do you utilize and recommend in your practice?
Yeah. So everything I do really involves informed consent with clients, right? They have to understand things both on a legal basis, but really on a practical basis, and obviously have the capacity to do so. I mean, I'll share with everyone that I found it's virtually impossible for me to mediate a case where there's a question about someone's capacity. Many of those cases, I will insist that they have a consulting attorney. I can strongly encourage that they work with a mental health professional. But again, if they don't have the capacity and there's not an understanding, and I'm concerned, regardless of how much I try to educate, parties about the law and long-term and short-term consequences of an agreement, it still goes back to that capacity issue. So in those cases, I usually will insist on a consulting attorney and will strongly encourage them to meet with a mental health professional. Look, practically, and, kind of jumping onto what Gitu said about discernment, sometimes people are just not in the right mind space to be negotiating and going through Family Code 4320 factors and negotiating very difficult and complex legal issues, spousal support, property division, everything else, and obviously co-parenting children. Sometimes it doesn't have anything to do with a clinical mental health issue, but some of the themes that Gitu described for discernment counseling, where you have a leaning in spouse and a leaning out spouse, and they're just not right emotionally as far as being able to negotiate those issues. So I'm very liberal about, encouraging couples to do discernment, because frankly, It may be a little too far to use the word capacity, but I find it virtually impossible because of the emotional issues, to be able to get them to negotiate financial or other issues in their family law case.
So how about, things like emotional flooding that might come up when there's infidelity or trust issues?
Yeah.
Do you use coaches at all in certainly in your collaborative practice to help with that? And could you explain a little bit for folks who don't work in that area, what that looks like?
Sure. So in the collaborative model, and again, when I describe collaborative, we're talking about a formal stipulation that's filed with the court. The professionals involved in the case cannot be used for any litigation purpose. But in my mind, going back to confidentiality, the biggest aspect of a collaborative stipulation is that all the professionals and all the work and all the communication we're doing is covered by the umbrella of mediation confidentiality. People need to know that the professionals are there to help them, as opposed to a concern that whatever they share could ultimately be used for litigation purposes. In a collaborative model, there's always at least one mental health professional, sometimes a one coach model where you have a coach working with both parties. In some ways I see it akin to family therapy in terms of that kind of model. Sometimes there's overlap with mediation as far as the mental health professional. And then other collaborative cases, we have a two-coach model where each party has their own individual coach. And there's an authorization for the mental health professionals to speak with one another and to speak with the other professionals as part of the collaborative team. It's absolutely necessary for the process. You don't need a signed collaborative stipulation, Ellen, to bring in coaches, and in mediation, I will often encourage that. I would say more than half of the mediations I'm involved in, there's a mental health professional actively involved in the mediation team. And it can be everything from, my literally co-parenting with that, co-mediating rather, with that person in the same room, to the mental health professional working with the parties on a track of co-parenting outside of the work that I'm doing on financial issues and mediation. The coaches, Ellen, that you described, where they're working to deal with emotional aspects of it. And I'm a firm believer that mental health professionals can play a big role in terms of the resolution of financial issues in family law cases. I mean, mentioning Family Code 4320 and spousal support, I don't know how anybody can read that code section without some emotional triggers to it, because it deals with the past and things that happened during the marriage. It, of course, deals with the present, but it also contemplates the future. That really is what spousal support is all about. And I love working with mental health professionals on issues like that, because they're very, very challenging. You throw into the mix things like betrayal or infidelity, or a leaning in spouse or leaning out spouse, somebody who doesn't want to get divorced. I can't say it's impossible to resolve it without the involvement of a mental health professional, but it really makes it much better, and it's a far richer product for the clients working with them. And in addition to dealing with the legal and financial aspects of their divorce, concurrently dealing with the emotional aspects of it as well.
So you've also used mental health professionals when we're talking about disposition of the family home, which is not what most of us first think about when we think about mental health professionals being involved.
Absolutely, right. I mean, for a family lawyer, or Judge Silberman, cases that come in front of him, it's a number. It's a net equity number, right? And the options are very limited, right? One party buys the other out, or a sale. We don't see a lot of things like deferred sales, at least in litigation and mediation collaborative. We can certainly expand our options to include that. But yeah, I mean, the family home is a huge issue. And going back to the trends that I'm seeing, during the pandemic, college-age kids, maybe staying home a little longer, maybe having part of their college at home, the connection that people have with their houses, the feeling that for their kids' stability, not selling a house now, or even pursuing a buyout like the mediation I had all day today, where it was very clear that financially, the person who wanted the buyout simply couldn't do it and just needed that kind of reality testing. But again, it's a very emotional thing. It's not the linear, sell the house, do a buyout. I was hearing today about the hand-painted tiles and the children's handprints on the house when they did the remodel in 2010. Those are issues I need to work through. And as far as I'm concerned, those are emotional issues and not clear linear financial issues. So yeah, it comes up all the time when it comes to the family home, when it comes to spousal support. Mental health professionals are not just there to help with co-parenting issues or therapy. They can play a huge role as far as financial issues.
Ellen, no-fault divorce has many, many positive things about it, but it also robs litigants of a forum to work through some of the more emotional issues and to have some closure of the trauma of many of the things Jeff talked about: loss of family home, infidelity, things that are profoundly on their mind and traumatizing. And the family court does not have a forum for that, to work through those issues, because we've adopted a no-fault process. And so that's something we all have to think about.
And therapy is a good place for acknowledgement of all the pain and the connection, the financial connection with the emotions, and the hurt and the need for apologies or moving forward or forgiveness. So these are really issues that are more appropriate for mental health professionals to be able to help in the whole process.
Thank you. Your Honor, when we were preparing for this program, one of the things you described was how the court process can sometimes make it even harder for folks to acknowledge mental health issues. And you talked about a weaponization of mental health. Could you talk about that a little bit?
Sure. Well, in a lot of custody litigation, every potential flaw is used as ammunition somehow, as if somehow or other denigrating the other side and vilifying them for this or that problem, some of them related to clinical mental health issues, somehow would advantage the person putting them forward, rather than another kind of medical issue that the family has to deal with and should deal with together. They weaponize it, and suddenly it's a danger. And I try very hard in many ways to diffuse that as best I can early on. And I've used things like the qualified medical examiner process, or some sort of mini evaluative forum where I can just ask one question, considering what the problem is, whether it's bipolar issues, whether it's schizophrenia issues, whether it's addiction issues. Is the parent a danger to the child if and when left alone? Give me an answer to that one question so I can try to diffuse this weaponization of what are medical issues. And we try very hard to do that. That's also a difference in the way people litigate, which I've spoken about in many forums to many of the lawyers, but still the old-fashioned way of doing things is let's file an RFO and say how terrible the other person is. Of course, I can tell you all and share with you what all my colleagues say to that, every one of them, which is, well, if the other person is so terrible, what does it say about your client who picked that other person? But nobody seems to think about that. It's just let's really vilify as much as possible, or let's reduce medical issues, whatever they may be. If there are issues, for example, of addiction, those have to be dealt with. Nobody's saying they don't, but they have a better outcome for children if they're dealt with as a family medical issue than if they're dealt with as fodder to gain an advantage in custody litigation. So it's a real problem with the way attorneys present these things. Now, I understand a lot of times if an attorney shares with their client a more holistic way to litigate a case, deal with those issues, the client may fire them because the client wants somebody to go in there and just be a pit bull. And so I get the problem in that sense, but ultimately everybody has to decide what kind of legal professional they want to be and what they can live with and how they can sleep at night. And a lot of that has to be with greater focus on child-centered litigation. I don't think that an attorney hinders their ability to forcefully advocate for their client if they do it in a child-focused manner. I can tell you in my court, you gain advantages for that, not disadvantages. And, but it certainly often gets away from what should be the main focus, which is what's in the best interest of children.
We're running short of time, but Your Honor, if you'd let me, I'd like to do kind of a lightning round of different mental health tools that you use in your court, because we did discuss them at length. We've already talked about qualified medical exams. Do you find child custody evaluations to be of use?
I can't find it too often, though. I think that they're asked for because, well, it's a really hard case and let's get somebody in to tell the judge what to do. When I do have an evaluation, a number of things have to be clear. I have to have a clearly identified clinical issue that I need expert testimony on. If it's just a really hard custody case, well, that's my job to hear that and to make those hard calls. So if it's clearly outlined for me what the clinical issue is, then I need expert testimony on that clinical issue, then I will use evaluations, but I don't take recommendations. I should be able to read the data and the analysis of the data, and that's it. If there are recommendations in evals, they can go to the lawyers for settlement purposes, but I don't take them. I make the decision after I receive that expert testimony the way I do any others. And I think it helps the evaluators also because they're not under the pressure of thinking, well, the judge is going to listen to me and it's going to be my call. With the people who do evaluations for me, they're pretty clear that they can tell the parents, well, I'm providing this information, but this judge is going to make the call. And I think that helps and gives a better playing field for a good evaluation.
Thank you. Parenting plan coordination, find it useful?
Yes. I think that we have to come to terms with the fact that our court system is not set up to deal with every issue. We have to understand our limitations. There are day-to-day issues that cause huge spikes in conflict that have a huge negative emotional impact on children and on parents, but mostly on children. And they're day-to-day things. If I get a series of those, I don't get to even hear about them for 6 to 8 weeks, long after they're gone. You know, so who made the medical appointment for the child and didn't notice the other party? That's long ago gone. And when those issues keep coming up and coming up and coming up, I think a parenting plan coordinator who can immediately make some basic rulings and provide order for the family is an excellent way to lower and decrease conflict when the problems presented are not something that the court process is designed to intervene with.
I just want to add on parenting plan coordination. I believe it's a very underutilized tool, right? It's not something that Judge Silberman can order. They have to agree to it, right? And literally give somebody, quasi judicial authority. But I find even in mediation cases, I need to know my limits, right? If I've worked with a family, I've worked with parents, and for years after their judgment is entered, they constantly have parenting issues. I'm very quick to suggest processes like parenting plan coordination. And my thinking behind it is what Judge Silberman, referenced, which is from a time and practical standpoint, a family court just isn't equipped to deal with day-to-day issues. And also the way I feel about it is it's a far more nuanced way of resolving things.
Past transactions or blockchain. This ledger of past transactions called the blockchain, as it's
then litigation is. So in a case that's high conflict where they come to me for mediation, I'm very quick to say, we have limits here, but don't litigate, because there is a process that I think can serve your needs. So I'm very quick to refer people to parenting plan coordination. I think it's underutilized.
Thank you, Jeff. Your Honor, child interviews, child input in your courtroom?
Yes, I will interview a child, but very careful selection of when I will do it. A couple of major concerns. Usually it's a high conflict case if I'm interviewing a child, and I'm extremely sensitive to the possibility of retributive behavior by the parent who feels they came out on the short end of the stick of the child being interviewed. So I do it very, very carefully. And usually it's also, I'll look to do it when I need to make it clear to the child that they're not in control any longer and that I expect them to do what I have ordered them to do. So yes, I will do it, but very, very carefully due to the fear of retributive behavior and over-empowerment of an already over-empowered child.
Our family wizard in the tone meter?
Yes, I use that a lot. Again, this is one of those changes that we talked about earlier, Ellen. I think years ago, I rarely, if ever, used the tone moderator, because I would kind of read the riot act to the litigants and then tell them what I expected, and I get a response. But the kinds of ways people talk to each other now is really very volatile. And so I find not only do I use Family Wizard for many reasons. Firstly, I remind them that all of the entries on Family Wizard are admissible as evidence to me. So Big Brother is watching their conversations. And also because it eliminates a lot of the he said, she said that goes on.
And you haven't ordered it yet for counsel, have you?
Well, I have suggested that there are various programs that counsel use in regards to discovery, because I can't even tell you how often I hear during the week, I don't have this document from counsel. Yes, you do. I sent it to you. No, I don't have it. I never got it. Yes, you did. I sent it to you. I can't tell you how many times I hear that during a week. So a couple of times I have suggested there are programs out there that will monitor the amount of discovery exchanged. I've even in difficult cases ordered everybody to bring everything in to a conference room in the courthouse. And I bring a third person in there to catalog what's been exchanged between the parties.
Okay, 3190 counseling, you do order it.
I do.
Confidential.
Yes.
whether or not asked to order it?
Yes, frequently.
And what kinds of circumstances, just a couple of examples where you might order it?
Well, a lot of times we have, major issues, boundary issues, parental anxiety issues, basic communication issues. I order a lot of also co-parenting classes and things such as that.
And
So
when you do co-parenting, you order more than the 6-week classes, is that right?
a lot of times what I've done in my difficult cases is I'll have them go to a provider for the 6 sort of basic classes. And I really like those classes because I think that it helps people being in a group, because a lot of times they can't see their own behavior. But when they see another couple going through a similar thing, if they're at all in touch with reality, they'll be like, well, I have to be honest here, I sort of recognize that behavior. So I really like that group model. And then what I do is if they still are having trouble, I will order once a month follow-up sessions with that provider for usually a series of 12 over the next year. And that follow-up often helps quite a bit.
Minors counsel?
Absolutely. Absolutely. They're a valuable tool, and some recent court cases are allowing us to go back a little bit to the old days with minors counsel. But again, I don't take recommendations from minors counsel. I think they're more effective when everybody knows the judge isn't just rubber stamping what minors counsel has to say. They're an attorney arguing their case like any other. And so they can be very, very helpful.
Thank you. Well, we're running out of time, but Gitu, I'm going to give you the last word. And I want to talk a little bit about family law professionals. We spent a lot of time talking about what this all means for our clients. What does it mean for us operating in an environment with this high level of distress, conflict, mental illness? What are the potential consequences, the occupational hazards, and what do we do about it?
Well, I think when we're working with people who are so traumatized and negatively impacted and high levels of conflict, it has to rub off on us. One of the analogies people have used is like secondhand smoke, and we do inhale it, and it does have consequences for us. And the other thing I think Judge Silberman had talked about, the incivility that has increased. And the analogy that someone's used about incivility and all of that is like, it's like COVID or like a virus that spreads. So if you're exposed to it, you're going to take it home with you in some form or the other. So I think we are vulnerable to secondary trauma or vicarious trauma, as we call it. When you're working with someone who's traumatized, you kind of carry some of it. And one of the consequences is compassion fatigue. And again, these are terms that the mental health professionals are very familiar with, but I think attorneys can relate to it, is that you stop feeling any desire to help people when you're so exhausted from seeing all the trauma and the conflict and the behavior that is just troubling all the time. And it's and burnout is a consequence of that. So we all are vulnerable to it. And one of the ways that we should think about protecting ourselves, or first recognizing the signs of it. So if you find yourself being short with people or spending too much time at work or not enough time at work, or finding that it's you're making mistakes or you're not able to function at the level that you're used to, then one of the things that you have to start thinking about is what are some protective measures, and having good boundaries, knowing what you can do and when you can't do and when you want to do it is one of the great things. And also peer support. I'm so fortunate. I've been in consultation groups and support so that you can talk about cases and get some feedback and get some relief from the kinds of feelings we're experiencing. Oftentimes we have blind spots about how it's affecting us. So when you are part of a study group or a peer support group, then you're likely to be able to identify that and acknowledge it and talk about it and get it off your chest. I think it's important for all of us to recognize it, and sometimes for attorneys to utilize mental health professionals as a way for themselves, but also for their clients, as a way of taking some of the burdens off your own shoulders can be helpful. So, I think self-care is really important. It's often talked about, but not fully understood. People think of it as, getting a massage or going to the spa or whatever, but it's a lot of other things that really help with self-care that we don't think about.
And I want to remind my colleagues that it's not only a matter of our own self-care, but attorney competence as defined in Rule 1.1b of the California Rules of Professional Conduct goes beyond having learning and skill, but it includes having the mental, emotional, and physical ability reasonably necessary for the performance of legal services. So even if you're not used to taking care of yourself, I know everyone is concerned about their professional competence. So do it for your clients, if not for yourself. I want to thank our panel. We could go on and on. We've had extensive conversations. I hope they've been as interesting to the audience as I certainly found them as we were preparing. And now I'm going to turn the program over to one of my co-chairs, Deborah Frank, and she'll help us to meet the mental health professionals. Thank you all. Deborah, you are muted.
Am I unmuted now?
You are, thank you.
Okay, great, thank you. Okay, is Genna on here so that he can assist me with this?
Jose
actually
is there
here.
to help you.
Okay, all right. So at this time, we're going to meet our mental health professionals. And I think this is the fourth year actually that we've held our Meet the Mental Health Professionals night. Thank you all for taking time to be with us today. We appreciate it. I'll be calling each of you in alphabetical order using the registration list. There are approximately, I believe it's 18 mental health professionals here. So you'll each have approximately 3 minutes to talk about your practice and services. Genna, my understanding is Genna will be muting and unmuting the participants during the program. And after that, we'll be breaking into 2 10-minute breakout rooms. Okay, so the first person we're going to hear from today is Tony Aloya.
Thank you for the invitation. For the last several years, I've sort of been under the radar because of unfortunate surgical accident that I experienced. And I no longer do child custody evaluations, which was always the tag on me. I've gotten out of that arena, which was my first real good move of self-care. And I do extensive work now in collaborative family law. I'm president of the Better Divorce Group in the South Bay area, which Jeff is a member of. I very much enjoy collaborative work because as an evaluator, I was always in a lonely position. Even when I went to court, I had to sit by myself away from everybody else. Now I can sit in a group of bright people who can give me support, and also people just can give me companionship. That's nice. I think the work that we're doing in CDR work is extremely valuable now, even more so. I talked to my colleagues who are still doing expert witness testimony in court and fighting the good fight. I'm still in a study group where we many of the evaluators that have been around for years and years are still practicing and hear what their battle scars are. I think that because of financial reasons, because of cultural differences, because of political differences, that the need for alternative dispute resolution is absolutely critical. I see my role now as preventing people from going to court, trying to work through those issues that they're going to have to be dealing with the rest of their lives, or as long as they have children. And they can start way before they get to court, or before they decide that that's what they really want to do. I think discernment is really important. It's already been talked about. I think the co-mediation that I do, the work with attorneys and financial specialists and other of my mental health colleagues is very important. Also, it gives us a chance to have interdisciplinary training. We talk the same language now. We share with each other their expertise. We understand some of the legal issues. They understand issues about trauma and issues about co-parenting. So we're able to educate each other. And I think that is one of the key things that keeps my juices going after practicing for over 40 years. And I think that more of my mental health colleagues are going toward this because of the stressors of litigation, and also the fact that certain legislative issues like Sanchez for evaluators of really making obsolete some forms of custody evaluation and limiting roles in that area. But now I find that I've got more business than I can handle in terms of mediation, co-mediation, parenting plan coordination, as Jeff mentioned. And I'm now focusing on that and not thinking about going back to court.
Okay.
Thank you. Thank you for the opportunity of reintroducing myself.
Thank you. Let's, I'd like to call on Alice Levialet because I understand she has to leave early. Hi, Alice.
Hi, Deborah.
Good to see you.
It's nice to see a lot of people that I've known over the years. I have been working in the field of domestic violence since 1978 with survivors and perpetrators of domestic violence. I have a group in West LA. Almost all of that group now are men who are going through high conflict divorces. I call it the DV light group because they have less of a history and more of a rage problem going through divorce and separation. I also have a broad-based private practice. Right now, I actually have 4 female clients going through child custody situations. I've done some co-parenting work. I do a lot of work with high conflict and anger. I also do with some regularity expert witness for the court, and will rarely do it for a client. If I have a client that I can do no harm, I will. I think I can do some good. I will testify, but and then I do a lot of training and public speaking on gender and sexual harassment, domestic violence, clinical issues, and anger. So basically, the kind of work that you're talking about, I have been doing for since 1978 in a shelter, but since 1984 in private practice. And I do have connections with other therapists who would be willing to do some of this work. Although, as I think Jeff was saying, and Judge Silberman was saying, I think Gitu said it too, that most therapists do not want to be subpoenaed to go to court. A lot of the work I'm doing, and Ellen has referred to me, different people have referred to me to calm people down before they go into the court process, or to try to get them in a place where they can actually sit in court. And I do a lot of that work where I'm trying to get people focused. When Jeff was talking about the financial issues, some of the co-parenting work that I've done is to try to get people to see, you know, knowing some of what goes on at family court, some reality in what they're dealing with. And also one of the things, for instance, I have a lot of, on the West Side, not so much in Long Beach, but on the West Side, very wealthy clients who have had spouses in heterosexual relationships, spouses who are at home with their children, and then they get in a custody battle and they don't get why their partners are fighting with them. And I say to them, you know, when you are dealing with your job and your expertise, how would you feel if somebody came into that expertise and told you how to do your work? And they said, I wouldn't like it. I said, well, for a lot of your partners, they feel like their expertise is raising children. And when you come in and take that away and you want shared custody, they lose their meaning, they lose their job, they lose a whole lot of things. So just as a way of understanding, I try to build in some empathy for the men and women that I work with. And I think that's really important in calming things down. And what Tony was saying about collaborative, you know, that's kind of the framework I come from. So thank you very much, everybody. Thanks for all the good speakers tonight. And it's really nice to see people that I've known over the years.
Okay, thank you. All right, I'd like to ask people to limit it to about 3 minutes if possible, so that we can have everyone speak tonight. Okay, how about Misha Ellis?
Hi, everyone. Thank you so much for this great presentation. I'm Misha Ellis. I'm a clinical psychologist, and I have a private practice in the Torrance area, and I am seeing clients for therapy. I'm seeing them only virtually, but for custody evaluations, I see them virtually and in person. And I'm still having people mask. Well, LA County is still doing that. But for therapy, it's only virtually at this particular point. And so, as I alluded to, I conduct custody evaluations as well as provide treatment. In terms of custody evaluations, I work with move away cases when there are abuse allegations, as well as straight custody evaluations. For clinical work, for therapy, I do individual therapy, couples therapy, as well as family therapy. I do co-parenting therapy. I also work with families who are going through divorces and just trying to help them navigate that process, or post-divorce, helping them to make the adjustments that are needed, as well as dealing with step families when that tends to occur. In terms of clinical specializations, I am a certified sex therapist. I'm also a certified Gottman method therapist. I have extensive training in emotionally focused therapy, as well as I am licensed in California, Georgia, Tennessee, and Nevada. And because I am licensed in Georgia and Nevada, the two states have agreements with additional states. And so when I'm in those states, I'm able to do work with clients who are in additional states, but it's on a limited basis. I want to be respectful of the time. I appreciate you having me speak, and invite you to reach out if you have any additional questions.
Thank you. Thank you. Babette Fleischman. Hi, Babette. You're muted here.
Okay, can you hear me now?
Yes.
Thanks.
Yes, thanks.
Hello to all of you that I haven't seen in a long time. There's many of you, and many of you like Misha that are new friends. And I'm grateful to meet all of you and be able to talk to you and tell you that I retired from the practice of law after 45 years this year. I have been a family law specialist since the beginning. And a few years ago, I went back to school at Pepperdine at night and got a master's degree in psychology. Misha knows all about this. And was very fortunate to have a very good internship, both in general, which is required to get your license, and in specifically with regard to a forensic internship. And I feel that I've been fortunate to be really well trained by some very good people. And I have started in 2016, I opened my therapy and child custody practice, both. It's called Insight Counseling and Forensic Services. And I just have a new website that went up. So if anybody is interested, you can look at my name or insightcfs.net. And I'm grateful for the opportunity to speak to all of you. One, to see a lot of my old friends from practicing law, and I wish I could wave and shake your hand and say hi in person. And also to let all the rest of you that I don't know that I am doing this work. I am doing traditional child custody evaluations, but I do have a particular interest in working with teens and tweens, and particularly on this subject, which I've come across lately quite a bit in evaluations of gender identity concerns by children of those ages. And I've done a lot of work on it since I started finding this out, that I have so many children that I've seen that actually raise these concerns in today's world. And it was shocking to me at my advanced age to realize how prevalent this is. So I've been doing a lot of work on it, and I'm particularly interested and feel somewhat competent at addressing these issues with teens and even tweens. It has come up recently in one of my cases. So I'm interested in talking to anybody who wants to know more about me, and I'll be happy to give you any and all information you need so that you feel satisfied in using my services if you do. As I said, I'm no longer practicing law, which is, after 45 years, a great relief. And now just devoting myself fully to insight, counseling, and forensic services. Thank you so much.
Thank you. Is David Kuroda here?
No, I'm David Kuroda, worked for the Superior Court for 18 years. I was the division chief in charge of the mediation program and the family court services. And I'm glad to be on this call because the rumors of my demise and retirement are greatly exaggerated. So I'm here. I'm still working. I have retired. I have resigned from the Family Law Executive Committee, from the divorce, from the West Side Collaborative Family Law, and I no longer go to conferences, but I am still very involved in the clinical work of children and families. You know, the reason that we have so much work now with the court is because of Family Code Section 3190. And when I was at the court, we reviewed that bill, and because it passed, it enabled family courts to order different kinds of counseling for litigants. And it was a very, very important bill for mental health professionals. I want to tell a story briefly about being in a study group with mental health professionals, and there was one lawyer, and we were talking about therapy with children. And one of the mental health professionals said, you know, the problem was the attorneys. The attorneys always make things worse. And then someone else said, yeah, I agree. The attorneys are the ones that really complicate things. And so everybody was piling on the attorneys. And the one attorney in the room remained silent. It was Peter Spellman. Finally, I raised my hand and I said, you know what? Attorneys care about children too. Attorneys care about people. attorneys have families of their own. And I don't think the problem is because of the attorneys. It's how we mental health professionals see attorneys and work with them. And I think the more we can work together, the better. So I think it's pretty significant that the Beverly Hills Bar has this annual event that you put on, that Ellen has really chaired for years now. And I think it reflects the partnership that we have, the collaborative association with lawyers and mental health professionals. So that being said, I resigned from a number of committees, but I am working in most of the areas. And I think one of the perplexing problems that we have now is the reunification case. And I think a lot of these cases are ordered for us because judges are reluctant to deny visitation to one parent. And so rather than deny visitation because one parent doesn't want to, we often are given these cases, and we can't resolve these cases in a way that parents always want. But I think the judges feel better about ordering these cases to mental health professionals. And I think that's one of the reasons we have these cases.
Okay, thank you. Linda Hayes, she here?
I'm very happy to be here. My introduction to the Department of Family Law came in 2001. I previously worked about 10 years in inpatient psychiatry. I got hired on by the LA Superior Court under Susan Thrall. I think Judge Harvey and I started approximately at the same time at the LA Superior Court. So we kind of grew up together. So that was kind of fun. So I have a real fondness for Judge Harvey. Yeah. So I worked for 16 years as a family court services specialist, where I believe I received the most fantastic training from the supervisors at the court. I got to do approximately 6,000 mediations and over 400 PPA 2s at the court. At the time, I didn't think it was so fun, but now I view my experience there as completely invaluable. And I got to meet some really great people like Karen Manger, who's here, and that I have a lot of respect for. So I also got to learn how to teach the high conflict co-parenting class, and I did it 72 times at the court. And now I do it in private practice. So I retired from the court in 2016, and I opened up a private practice. In my current practice, I do some PPA 2s, I do mediations, I teach the high conflict class in private practice, and I do a lot of co-parenting counseling. There's a great need for that. And I actually enjoy it, believe it or not, even though there are a lot of times when parents like to spend their time just criticizing and yelling at each other. But over a certain amount of time, they learn to co-parent better. And I find that to see that transition from being that high conflict set of parents into a more cooperative set of parents, I find that to be very enriching for me to be able to help them with that. So I wanted to make a comment about using associates as to train them. I have an associate, an MFT associate, and I have been working with her for the past 4 years, and she teaches my high conflict class with me, and she's of such great value to me. And she's gotten so clinically strong that I really appreciate that. Her name's Joanne. Some of you have met her. And so I'm a real advocate for training new people as they're about to come into our field. One other thing that I wanted to make a pitch for is that when attorneys request, for example, co-parenting counseling, or request certain kinds of therapy from those of us that are experts in family law, that I would encourage you to ask your judicial officers to put it in order for the therapists that are involved in a case to be able to work collaboratively, so that I will be able to, for example, if I'm the co-parenting counselor, I can speak to the child's therapist, and I can speak to the parent's therapist, and that we work as a team with a similar goal in mind, which always is led by, as Judge Harvey's always told us or told me in courtrooms, when you lead with the child's best interest in mind, then you're going in the right direction. And I repeat that phrase over and over and over in my high conflict class, because I truly believe that. And so if you're in court and you remember to say that, ask the judicial officer to give those of us who want to work as a team and collaboratively to make that order, because when it's not done there, and you ask the parents to agree for us to talk to each other, they often will not agree. They want to fight that concept because, they don't want us to work at a team sometimes. So it's unfortunate, but it's true. So that's my request for everybody, is that you encourage that teamwork, because we're all in it for the kids, and that's where my heart is. And thank you for having me tonight.
Thank you. Renee left.
Hi,
Yes.
I'm Renee, and I want to thank Linda for making that recommendation to everybody about requesting the judicial officer to put names and very clear specific terms into the court orders. I also have an informed consent, so that before I take a case, one of the conditions in the informed consent requires each parent to sign and validate that I can go forward and meet with all the members of the team, including the attorneys, so that I can work towards the best interest of the family and the child. So that's another way of trying to make sure that we can work collaboratively, is to look to our informed consents. Anyway, I've been around for a long time in the family court system, probably 20 years, doing various types of mental health work. And right now, my practice is primarily concerned with two aspects of it, which is the co-parenting and some reunification cases. I'll take a reunification case if I feel, after screening the people, that there's a chance for a positive outcome for the child, and not if I feel that I will be creating a situation where the child undergoes more trauma than he's already can manage. With co-parenting, I really enjoy the work. I have found over the years that 6 sessions is not enough to really make any kind of a difference with co-parenting cases, at least the high conflict ones. Generally, people who are just undergoing divorce can really benefit from the 6 sessions, but high conflict parents who are in entrenched kind of intractable positions need a longer time with me and with each other. I found over a period of months, a couple times a month, over a period of 6 months, there is enough time to develop new habits in people, but it does take time, and it takes consistency, and change can occur. So I really like that work. And finally, I just want to say I really appreciate Ellen and Deborah, you bringing us together every year, because it's great to see these faces and to see new faces. Ellen and Gitu and I were part of a study group, a collaborative study group so long ago. I've seen David for years and years, and it's wonderful to see his face every year. So thank you both. Hi, Judge Harvey. I really appreciate you too. He's my hero, my secret hero. I've gone into some consulting work. I consult now on reunification cases and various aspects of high conflict cases. And thank you. Thank you all. Bye-bye.
Jeff Lulo.
It's good to be back here. It's good to see that David still isn't retired. Glad to see that. And it's kind of sobering to me to realize that as of December, I will have been practicing as a licensed psychologist for 50 years. And there was a time when I thought that 50 years was old just if you're that old. But there's all that years before that besides. Most common question I get, or most common comment I get when I tell people that I do child custody evaluations is, gee, I'm glad I don't have your job. But I like my job. I do child custody evaluations. I enjoy doing them. I find them fascinating. I learn new things every day. And I find that I am in a unique position in the courtroom in that I'm the only one there who has talked to everybody and gone to their houses and talked to their friends and have been able to get a complete picture. Well, not complete, it's never complete, but the larger picture than can be presented in the courtroom. And I'm hoping that that's valuable to the judges. I try to make it valuable. I started out doing child therapy. I did that for 15 years. I set up a child and family services part of a large medical group, which at the time was the main competition to Kaiser, but they disappeared into Cigna, and Kaiser kind of won that battle. At any rate, I enjoyed doing that, but I enjoy doing the custody evaluations more because I get to see the whole picture. I also, as part of my practice, I conduct neuropsychological evaluations, often for accidents and personal injury cases, and testify in such cases. With that background, I have an ability to work with children who have learning disorders and to evaluate such disorders, and sometimes that's very valuable. At any rate, I appreciate the opportunity to be here and to present and to see familiar faces. I'd like to see everybody in person again. And the last time this was done in person, the food was terrific. So today I had to just make do with a sandwich that I threw together. But I'm looking forward, I hope, to another time when we can all get together in person. Thank you again.
Thank you. Karen Manger.
Hi, everyone. Great to see some faces I haven't seen in a long time. And thank you, Ellen and Deborah, for giving us a fantastic program and taking this on every year. I too started my family law career at Family Court Services, in the Superior Court. And I too sort of grew up with Judge Harvey and with Linda. And, you know, I want to sort of second what Linda said. It was amazing training. We saw a little bit of everything. We had to be quick on our feet. We had to learn to make quick and hopefully accurate judgments of people. And I don't think I could have gotten better training anywhere else for this type of work. I was at the court for 20 years and then left 10 years ago, and I'm in private practice now. I still do some child custody evaluations. I am starting to move away from them. I find them, unfortunately, to be really adversarial. When I worked at the court, I found them to be really helpful. And I think that The judges appreciated them, the lawyers appreciated them. I'm not doing many custody evaluations anymore. I'm moving more towards clinical work, which I'm really enjoying. I do a lot of co-parenting, reunification, and child therapy. I do some PPC work. And I want to say, I think David brought this up, and Linda as well. I think that this work really needs to be done as a team. I find myself, especially in reunification cases, I always start them with a conference call with the attorneys. I find it really, even though I'm not in collaborative law, I find it important that we all work together and we're on the same team and moving these cases forward. I can't do it all myself. Sometimes I need to call the attorneys in and say, your client is being really difficult. What can you do here? And I've found, for the most part, that attorneys are really receptive to this and have been really helpful. I also agree with Linda that working with other therapists on the case is also really important, and helps, I think, all of the moving parts sort of know what they're doing. So we're not working against each other, rather we're working with one another. The last thing I want to say, I think which would be really helpful, and I know that Judge Harvey does this a lot, is to afford the therapist to come in and give progress reports, whether it's in a conference call or in a Zoom call, and to let the judge know where the case stands. And I think that psychologically, that's also really important for the clients to know that they are going to get a progress report and the judge is going to know, what they've been doing or not doing. So I want to end with that. Thank you very much and good to see everyone.
All right, thank you. Okay, Robin Sachs.
Hi, everybody. I love that I'm coming after what Karen just said, because I am a former prosecutor, lawyer turned therapist. And one thing, just as a comment on progress reports, that carrot of having those every 90-day reports keep people very compliant, and is a really great behavioral mechanism. And I also, borrowing from the criminal law world, I came at this starting my career as a sex crimes, child abuse, domestic violence prosecutor, always right next door to dependency and family law. So I fancy myself as being trilingual in that I can speak family, criminal, and dependency. And I'm basically a lawyer that doesn't practice law and a therapist that doesn't do therapy. I enjoy mediation and PPC work. I do co-parenting work. And a lot of people, I work really well with clients because my bossy lawyer side comes out with my therapeutic loving side, and it's a perfect blend of where mental health meets the law. And I've been trying, Babette, to get in touch with you because your LCSW tutor is my LCSW tutor, Natalie, and I've been trying to find you because I also started a group called Therapists at Law, which are for people who are jointly degrees, both as therapists and as lawyers. So in hearing all that, you can hear an echo that I totally am a believer in what Linda and Renee and Karen are talking about. I come from the multidisciplinary team background. I came from working on multidisciplinary teams at UCLA Rape Treatment Center, Violence Intervention Program, Harbor UCLA, and really believe that when all the wheels are moving in the same direction and everybody works together and you can kind of case manage and have that behavioral compliance aspect, you can actually start to see progress. So I'm an old lawyer, new therapist. Although this is my 4th year being here, I'm really, really thrilled. And I really come at this not only as someone who has professional experience, but as someone who has been through a divorce. I married someone, I became a stepmom, I got divorced. My ex-husband married someone else. My daughter has a stepmom. I'm in another blended family, and we're one big, crazy, fucked up blended family, but all seem to work pretty well. And I speak at this because I know what it feels like to get that email on Christmas Eve at 5 o'clock when you're sitting on the beach in Cabo, and how dysregulating that can be. But I also know how amazing the work of a co-parenting therapist can be in keeping your lives on track, because it was a therapist that saved my child's life, my life, and I really believe in the work that we're doing. And so I thank you all.
Thank you. Is Jeff Arden here?
Hi, everybody. Thanks so much for tonight. It's been really fascinating. I wanted to comment on Judge Silberman. I remember a couple of years ago, I got an order from him to see this family, and the order said, and you're to do this, 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 and this. And I thought, oh my God. But I just went ahead and followed it blindly, and it actually worked. The people started behaving. So it was a new and interesting technique. But it's nice to see everybody. And Deborah, thanks so much. And it's good seeing everybody. Gitu and Jeff, who I had the pleasure of doing one case with. So, all right, well, thank you very much.
Okay, thank you. Carl Hoppy?
Yeah, thank you very much. I wanted to add to something that David Kuroda said about reunification therapy. It is vitally important that the preferred parent also be included in any orders for reunification therapy. So many orders come in that the child and the estranged parent are to have reunification, but the key to the situation is in the preferred parent often. I have done a lot of personality evaluations for other custody litigants. That's what I'm best known for. I've seen thousands of individuals. I have a large database of specific scores of custody litigants. I have done a few 730 evaluations. I'm backing away from them. They're just too long, too expensive, and too contentious, and it takes too much time. I do therapy with individuals who are going through or contemplating divorce, working with the anxieties and the resentments and the fears that accompany that situation. So I think briefly that's what I wanted to say. I don't want to take up the rest of the evening. Thanks so much.
Thank you. Let's see. Dr. Sheeran, Kim Sheeran.
All right, I unmuted, I hope.
Okay, good. Thank you.
Okay. Well, I wanted to thank everybody for, the invitation, and it's good to see a lot of the familiar faces, like several people have acknowledged. Primarily, I'm, besides being grateful to the Bar Association for hosting this, I think it's incredible. Primarily what I do is evaluations. I do some 733s and some reunification therapy. I see my role as a gatherer of data to try to help the judicial officers be able to make educated decisions on how we can raise healthy, productive children. I think I agree with what Renee was talking about. Co-parenting needs a whole lot longer of time. With reunification, I think it's important you have, as Carl said, we got to have the preferred parent involved. And just like Jeff, I love what I do.
Okay, that's great. Okay, Gitu, you need to introduce yourself also.
Well, thank you. Thank you, Ellen, for inviting me to be on this panel. I learned a lot. I just wanted to say, actually, I go back a long way. I did my internship in mediation at the Conciliation Court in '84. So almost 40 years ago now. And I've been, and David Kuroda was one of my first bosses, actually first boss. So I've been very fortunate to have had great trainings during this time, and I do individual counseling, couples therapy, post-divorce counseling, and co-parenting counseling, in addition to mediation, co-mediation and mediation for custody issues. The other area of expertise I have is cross-cultural psychology. So I do provide consultation for therapists and attorneys on cultural issues when they show up with intercultural marriages and things like that. And I have been trained in collaborative work, and in small collaborative forms and real collaborative work. I enjoy working in an interdisciplinary format, and always feel I learned so much from the other groups. So thank you again, Ellen, for inviting me to be part of this great panel.
Thank you. Is Joseph Mckenzie?
Hi. I'm also have a couple of degrees as an attorney, and I'm licensed as a clinical social worker. I have worked in dependency courts, mental health courts. I've been in every psychiatric hospital in Los Angeles County. I work with mentally disordered sex offenders and other difficult folks for a number of years. This is one of the better programs I've ever had the opportunity to participate in. So thank you for this one. Everything that you are all doing is very important to me. I've worked in the dependency court since 1972. What do I want to tell you? It's just I just appreciate the opportunity to be here. Thank you very much.
Thanks. Is Carla Gonzalez still here?
Hi, good evening. So I do have to leave. I was just told about this event by a previous Family Court Services colleague last night. So I moved a client to 7:30 and I heard them knock. So I'll be very quick. I am a bilingual licensed marriage and family therapist. I've been privileged to have been on both sides of the work. So I was previously a Family Court Services specialist under Susan Thrall, mentored by Linda Hayes as well. And now I'm doing private practice work, mostly focusing on co-parenting work, family reunification therapy, seeing children whose parents are high conflict or going through a separation or divorce. I am trained to treat trauma and parent-child relationships. I have also been mentored by David Kuroda as well. So just a little bit of feedback. Yes, I do appreciate when I get clients sent, referred by the court or attorneys or minors counsels, when there is clear guidance from the court. That's super helpful. And also speaking to, in post PPAs, to the evaluators to get a good sense of what they wanted the therapy to focus on. Super valuable. Collaborative work is very valuable with either the parenting plan coordinators, family therapists, or the child therapist. And it's pretty lonely work. So if there is consultation groups out there, that'd be so wonderful. I think I got a couple emails, so that would be great. Thank you so much.
Thank you. I think we still have two people that haven't been heard from. If there's anyone else, please let me know. Is Sean McCoy here?
Thank you to Deborah and to Ellen for putting this together. And it's so nice to see so many people that I haven't seen in at least 2 years, if not longer. And Tony, I hope you're feeling better. I know it's been a rough go.
No, I'm hanging in. I'm hanging in.
I'm glad to see that. I'm glad to see that. So
Thank you.
kind of like Jeffrey Lillo said, you know, I've been doing this a long time. My first custody case was in 1983. And also want to say hi to Joe Mckenzie. He and I got our master's degrees at SC in the early 70s. So we go way back. We don't see each other often, but I remember him. So 83 was my first case, and I think the last 7:30 custody evaluation I did was right before COVID. And I haven't done any since then. I doubt that I'll do any more of them. I wasn't comfortable doing them without in-person contact. So I would say 70% of my practice these days is providing consultations to law firms specializing in family law, and also to their clients and helping them get through the process. Also, as a consultant, I also prepare deposition questions, trial examination questions of other experts. I also do mediation. I've been part of a mediation team on several cases with Lisa Hacker. And like other people have said tonight, I find it very rewarding. It's nice to have colleagues to work with and to try to make an impact as a group. The last thing that I do is testify as an expert witness. I critique child custody reports. And, you know, I must be asked 4 or 5 times a week to give the names of 3 evaluators that I think are good and can do a good job. And as everyone knows, the landscape for custody evaluations has changed with Sanchez and with Mary Lund, Angus Strawn, Ian Russ no longer available. So it's more difficult. And, you know, it's nice to see Misha Ellis. I've probably said her name 5 times this week and recommending, even though she's not available till I think July or something. I think Al Gibbs is not available till July. So some of these people that are kind of known entities are just not available, or it's very difficult because the attorneys still have to prepare their case. They still have to put on their witnesses, and these custody cases don't seem to be going away. When I started back in the 80s, I remember with Harold Cohen, he was my first attorney that I worked with. And I always thought that there would be some resolution that would come up other than litigation to resolve these cases. And Harold said to me, you know, Sean, there will always be parents who are going to fight over their kids. And unfortunately, that's been the case. Not only is it the case, but I think the parents that we're seeing these days are even much worse than the ones we used to see decades ago. And if you think about it, you know, at least the old statistics were 80% of custody or parents divorcing could resolve their custody issues. That left 20%. Of those 20%, 80% of those would resolve their custody issues prior to going to court. In Los Angeles County, it used to be 2.75 of all filings in custody cases would end up being litigated. So there's something about those 2.5% that we all are dealing with that sets them apart from the other 97.5% that were able to resolve their differences. So I think there is a high burnout rate. I think it is very stressful. People are not wanting to do the 7:30 evaluations anymore, primarily because you have to join that family, join that system. They're very dysfunctional, they're chaotic. So while you're doing that evaluation, you're part of that system. And if you're doing 2 or 3 or 4 evaluations at a time, like we used to, it can be extremely wearing and taxing. I stopped after doing about 300. So it's nice to see new faces, and I don't know where it's all headed, but again, nice to see everybody.
Thank you.
Hi, Judge Silberman.
I think Carla Gonzalez left. Is Carla still here? No.
No.
Okay, how about Marcy Kraft? Is Marcy here? All right, is there anyone that I didn't call on?
I'm a former family law paralegal for 5 years when I got out of college, and a former psychology teacher at Beverly Hills High School. And I've been a licensed therapist for 40 years, a divorce therapy and co-parenting therapist and educator. I do discernment counseling, and I was former conciliation court family mediator and studied under Sherry, geez, I just lost her name, and Ernie Sanchez. So
Sherry Kibler.
Sherry Kibler, yes.
Yeah,
I had great training. I absolutely loved it. And I'm a current child custody and customized parenting plan mediator, and also trained in family law. So I help parents navigate their emotions to help them make informed decisions, not emotional ones, so they can work more cooperatively with their attorneys and other specialists. And one of the tools I use is the family tree. And with clients, I go back 3 generations, and we look at everybody in that family, and together we look at the family patterns of behavior that have been passed on down through the generations. And once they understand why they're doing what they're doing, it takes away the onus, and then it opens the door for some positive behavior. So by increasing awareness, we greatly increase positive choices. I love what I do, and I have a dedicated passion for helping parents stay out of the courtroom by mediating their child custody disputes and helping them create workable parenting plans for their reorganizing family. I want to thank Judge Silberman and Jeff and Gitu for the valuable information they shared today, and for Deborah and Ellen for putting this all together. It's been really valuable. Thank you.
Thank you. Thank you. And also, of course, Joe Langlois, who we haven't even seen tonight, but he was very involved. All right, is there anyone else that we haven't heard from?
Hey,
Okay.
Deborah, can I just say one thing?
Of course.
Before you go on. I just, you've seen me waving to all sorts of different people. There are so many of the people that spoke tonight that are heroes to me, because I was, when I took the bench 18 years ago, I don't know that I knew a fraction of what I needed to know. And the training I got from the likes of Karen and Linda and Renee and Sean and so many of the others, I'm just so appreciative of it. And you guys are often behind the scenes, but not in my book, you're not. You're right up there. And I just so appreciate it.
Okay, thank you. Thank you. Babette, did you have something? Your hand is raised. Did you want to ask something?
I was just waving to Judge Silberman, and because he was waving to everybody. That's why I had my hand up.
Okay, thank you. Okay, I think we've heard from all the mental health professionals. I thank you all for participating. It was excellent, very exciting.